Hello, I'm attorney Scott Lesowitz, and I assume you've heard the PGA Tour, the PGA European Tour, the LIV, and I think also Microsoft and Google have all agreed to merge into one giant super entity. So the big question, of course, is whether regulators will allow this merger to happen under antitrust laws. The US Department of Justice may attempt to block the merger, and there's already Senate investigations starting regarding the merger. And there's also the question of what European regulators will do, especially in Britain, since the European Tour is based in England. And you might be saying, how could this possibly be a monopoly? I mean, yeah, the super dominant US Golf Tour, the super dominant European Golf Tour, and the mega money super dominant International Tour would all be joining forces as one united mega super golf entity that could defeat Godzilla. But, come on. I mean, we still have the Japan Golf Tour. Apparently that's not part of the merger. One can imagine this being considered a restraint of trade or commerce under Section 1 of the US Sherman Act. And one could also see how these would be actions taken to monopolize trade or commerce under Section 2 of the Sherman Act. One can imagine that this could potentially harm everybody involved other than the golf tours themselves. Players will have fewer options. There'll be much more leverage for the new entity in terms of negotiating TV rights. It could impact the number of events. It could impact prices for fans, both for tending golf, watching golf, merchandise, etc. And apparently they are going to try to argue that, well, it's not really a merger, it's just a partnership of assets. However, that isn't necessarily going to work. The DOJ in the past has taken action against partnerships like this and said that, well, it's a de facto merger. The funniest thing to me, though, as an attorney, is the press releases that the PGA has put out. I assume they have attorneys because, they were involved in a bunch of litigation, but apparently those attorneys all just got their law degrees from Andrew Tate's Hustlers University or something. They forgot that, we should have the attorneys vet any press releases or things we put on our website about the merger because, people in government can read what we put out on our website. So in one article on its website, the PGA seriously says, where there was once rivalry, there is now unity, as the PGA Tour, DP World Tour, and PIF have in place a framework agreement to form a new collectively owned for-profit entity. And then it quotes the PGA commissioner as saying, to take the competitor off the board, to have them exist as a partner, and for us to be able to control the direction going forward, put us in a position as the PGA Tour to serve our members, and at the same time get to a productive position for the game at large. They really shouldn't be saying these things out loud. I am pretty damn sure that in any antitrust proceeding, that's going to be an exhibit. And there was a PGA press release announcing the merger, which described it as a landmark agreement to unify the game of golf on a global basis. So I think that besides the obvious concerns that may come to mind about the antitrust problems here, PGA has basically put out press releases saying, we did this merger in order to crush competition and be anti-competitive and gain a monopoly. All right, I'm sure this will be an ongoing saga, and so stay tuned. And in the honor of the late Jerry Springer, take care of yourself and each other.